Good evening, folks. This is Omar Serrato with the Tilted Lawyer podcast. And we perhaps have some breaking news. Well, it's not really breaking anymore that the judge has ruled on Gingras's latest motion to remove Judge Mata. I have in my hands the 9-page ruling. We're going to go over all of that. But more interestingly, we have our hands on his written response from the complaints, the latest complaint that was sent to the Arizona State Bar. And we may or may not be able to get to that on this show because we have to redact that document. And I don't want to risk reading it and in the moment read something that should have been redacted. I'd much rather just have it redacted before I go over it. So whether or not we're able to get to that after we go over the motion for Gingras that was recently ruled on, we may get into that, or we might, I guess we'll just have to see. But folks, you're going to want to stick around. It's going to be a good one.
Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
Good morning, evening. Good evening, folks. It's been a rough couple of days for me. I was supposed to go live. I was going to go live with some stuff yesterday, but I had unceremoniously a death in my family. Somebody that was near and dear to me, and so we're going live today anyway because life goes on, and we're gonna press on. But yeah, it's been a rough. But in the midst of all of that, this morning we were given a gift in the way of a ruling on a motion that David Gingras had filed seeking to remove Judge Mata. And the writing, I thought, was particularly snarky by this judge in a dorky kind of way. I'm going to comment a little bit about that, but we're going to read through this. I'm going to try not to read it word for word. I'm going to leave out the unimportant parts, but we're going to go through it nonetheless. Further announcements for the show. There's a lot of stuff that we're rolling out that are rolling out that were supposed to get rolled out yesterday, but unforeseen events and all. So that's forthcoming, but let's get to this motion. As you recall, David Gingras, who, by the way, is in the process. Well, I can't say that Gingras is doing this, but did you guys hear that Laura Owens has been going after YouTube creators for using copyrighted photographs of her that she used when she was doing the TED Talks or whatever, that photo shoot that she did? Back when she had first started emailing me, she had made mention that I put up like a post, and it was one of those, nicely done photographs that she had. And she said, "Hey, I don't like that you use my copyrighted picture." I said, "Fine, I'll just use worse photos then." And ever since then, every time I've used a picture of Laura Owens, it's been some kind of crazy screen grab from Court Live Feed TV that she could never claim has been copyrighted. And I guess it's worked because everybody else seems to be getting these copyright strikes, except for my channel, because I don't use copyrighted stuff. But she brought it on herself. And anyway, she's wrong in all of that. And YouTube agrees that she's wrong. And she's trying to come after Lauren Knighty and Dave Neal and Umbrella Guy. I don't know if there's others, but I heard on Dave Neal's show that she was doing that, not very successfully. You'll also fondly remember, I'm sure, when David Gingras, in the course of representing Laura Owens, unceremoniously, I'm using that word again, got his ass handed to him in every conceivable way possible, in all orifices. You'll do well to take note of the thumbnail for today's show, where he's getting dunked on with balls in his face. It was as clean of a beatdown as you could possibly have received, bringing a kind of case like what he brought. And he was justifiably embarrassed in court. Now, he went on his little Twitter rants, in his vacation rants, and his blog rants. Some of those have become the subject of bar complaints that we've read recently. And, you know, he's had a lot to say. And one of the things that he had a lot to say was he didn't like the fact that Judge Mata, among other things, he believed, in his opinion, after he was, I don't know, a few margaritas deep, that, well, it was so unfair. It's so unfair. Judge Mata's just so biased. I'm not trying to talk negatively about Donald Trump because I don't want to make it a political thing, but he's doing that thing where, he just starts making shit up. And, I digress, man. Where are we at with this? So yeah, he wanted to get rid of Judge Mata because he was really upset that her dad was being a proud father and a spectator of Judge Mata performing probably one of the most high-profile cases of her career, and seemed to think that was akin to, I don't know, some kind of inappropriate conversations with her dad. Well, Judge Fritz has heard his arguments, and she took a good look at them. She's thought long and hard about it. She's considered what he had to say. And she has, in so many words, said, denied, sir. Judge Mata will not be removed. But here is the motion. So let me share my screen so that I'm not just reading into the ether. Am I shared? We're shared. I don't know if I can make this any bigger. Let me see if I can. Here, I'll just do that. All right. So it begins. A party seeking a change of judge for cause must establish, and she just gets right into it. You got to imagine, too, this was attached to the pleadings and all of that. In order to, a party seeking a change of judge for cause must establish grounds by affidavit. Rule 6.1. One of the grounds which may be alleged for change of judge is that the party filing the affidavit has cause to believe and does believe that on account of the bias, prejudice, or interest of the judge, he cannot obtain a fair and impartial trial. He had to argue that because that's the rule and that's the law, and it's right there. The sufficiency of any cause to believe must be determined by an objective standard, not by reference to the affiant's subjective belief, which is a high bar to pass. It's really difficult to deliver objective arguments. Try it yourself. Go through the process of going through the Socratic method of answering questions and try to make an unemotional argument. It's really, really unnatural and hard to do. Evidenced by the fact that this guy, David Gingras, has been practicing law for, over 20 years now, and he keeps on talking about what an illustrious career that he's had, and he still fails to have the ability to make objective arguments at every stage in the litigation in which he's been involved. So what are we to make of that? Judge goes on to say, the case law instructs that in Arizona, a party challenging a trial judge's impartiality must overcome the presumption that trial judges are free of bias and prejudice. That's the same thing as like every defendant is guilty or innocent until proven guilty. We start with the presumption. That means if you're going to tell me she's biased, you got to give me the evidence, because I'm going to assume in the absence of evidence that she's free of bias and prejudice. And they cite this case. There's another case cited. Judicial rulings alone do not support a finding of bias or partiality without a showing of an extrajudicial source of bias or a deep-seated favoritism. A change of judge for cause is not warranted if based merely on speculation, suspicion, apprehension, or imagination. Imagination being the key operative here, I think, with David Gingras, because he is nothing if not imaginative and creative in the poetic prose. Is that a term? Poetic prose that he spins on his blog posts and the like. Instead, the party seeking to notice the judge for cause must prove bias or prejudice by a preponderance of the evidence, which is the lowest evidential standard in law, which is basically literally more likely than not. If it's 50-50, if it's 51-49, then you win. That's literally the standard. The court will separately consider petitioners' two claims of bias and or prejudice. So there was an allegation of an independent investigation by Judge Mata, and that was an allegation brought about on the strength that David Gingras had identified a singular instance in Judge Mata's ruling where she may have misstated the evidence. And he took that one fact, that one little factoid, and stretched it all the way into this conspiracy, how she has conducted a secret investigation that she was unauthorized to do. And therefore, she is inherently biased and has been manipulated like all the rest by the JFC crew and all of that. That's his argument, right? And the judge gives him credit, as I gave him credit for finding that one little fact. Good for you, Gingras. Good for you. Matter of fact, I gave him credit on a live that I was doing when I confirmed that indeed she has misstated a fact on which she based her rulings. At first, I was concerned, but then the more I thought about it, I was like, it's pretty tangential to the actual merit of the ruling, and so I don't think that that's going to go anywhere. So petitioner correctly points out that Judge Mata's July 17th ruling contains a factual error, i.e. the transcript from June 10th hearing shows that Dr. Samantha Deans did not testify that Planned Parenthood is not open on Sundays. See Exhibit E to affidavit. Judicial rulings alone almost never constitute a valid basis for a bias or partiality motion. Again, they're quoting state law and they're doing that for a reason. This factual error can be corrected through a post-trial motion or appellate proceeding. It does not, standing alone, indicate bias. You need to have a hell of a lot more than that. To demonstrate bias, petitioner asked this court to infer that Judge Mata's erroneous finding constitutes irrefutable evidence that she performed a secret, undisclosed investigation in the facts of this matter. Affidavit, page 93, and copied that finding from posts on social media, which was a stretch. In support of this position, the affidavit includes snips of a June 10th, 2024 comment on petitioner's counsel's website. Planned Parenthood isn't even open on Sundays in LA. And comment posted by an anonymous Twitter user on June 10th, 2024 at 5:08 p.m. It was a Sunday and all LA Planned Parenthood locations are closed on a Sunday. Yeah, there was a lot of people that those were like 2 of thousands of comments that I had seen like that. Give me 1 second, folks, while I shut the door. Oh, okay. Moving on. So the court finds petitioner relies on mere speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation and therefore is biased. The record evidence reflects conflicting testimony about the day, date, and location that petitioner obtained an ultrasound which petitioner admitted to altering. As Exhibit B28, which petitioner admitted to altering. Petitioner testified that when she was in California on a weekend, she had an ultrasound done under a fake name at a Planned Parenthood. That's in Exhibit 17, 20, 19 through 8. Before trial, petitioner had provided a declaration stating that the ultrasound occurred on July 2nd, 23 at trial. She changed her testimony to say it was an unspecified weekend in late June 2023. I like the fact that they're referencing that infamous moment where Laura Owens changed her story on the witness stand at trial. Petitioner further testified that she had altered the ultrasound to reflect the incorrect date of July 7th and the incorrect provider, Mill, instead of Planned Parenthood. Dr. Deans testified that she had reviewed the altered ultrasound and available medical records to prepare a report. That was admitted as Exhibit B41. Dr. Deans expressed concern about the legitimacy of petitioner's medical records. Dr. Deans confirmed that Planned Parenthood's national guidelines require identification at the time of visit to confirm the identity of a patient. The patient can't be seen anonymously. She did say those things. Dr. Dean's testimony did not address which days of the week the Planned Parenthood offices were open. So based on the foregoing, the court finds that when determined by an objective standard, not by reference to the affiant's subjective belief, petitioners failed to show by a preponderance of the evidence that Judge Mata's finding that Planned Parenthood is not open on Sundays reflects bias or prejudice against petitioner. Moreover, although not dispositive of the issue, the court further finds that this singular factual finding is of little to no importance given the rest of the findings in the July 17th ruling, which I'm very happy to see that statement, that sentence, because that's basically what my analysis of that little factoid was. It's not all that important in light of the entire ruling. So, on to the other allegation. Petitioner alleges that Judge Mata's father, Harry L. Howe, was present in the overflow room during the trial, spoke with several of respondents' supporters during and after the trial. Petitioner's counsel admits that the mere fact Judge Mata's father attended the trial is not the primary concern. Bullshit. For purposes of deciding the Rule 6.1 motion, this court accepts these allegations as true and finds that if they occurred, was not improper for Judge Mata's father to attend a public trial as a spectator and speak to other courtroom observers. Petitioner asked this court to infer that various statements made by courtroom observers about Mr. Howe confirmed that Judge Mata was biased or prejudiced against petitioner. Petitioner's counsel acknowledges that his personal view, based on the past several months, is that Clayton's followers are generally not honest or reliable. You see the same kind of arguments made, honestly, in like the 5th grade. When people give you like current events, your teachers give you like, write a paragraph about a newspaper clipping. Do they still do that nowadays? Then they say, I want you to make an argument about whatever. And then you'll see those kinds of arguments that are made. Nevertheless, petitioner's counsel asked this court to find that an edited compilation of these individuals' comments about Judge Mata's father are clear extrajudicial evidence showing that Judge Mata had a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants. Basically, what they're saying in so many words, when you hear language like that, nevertheless, when you hear that word, nevertheless, and it's written in a judicial order after she has read the merit of your argument or the premise of your argument, you know that they're basically dunking on you at that point. Petitioner's counsel asked this court to find that an edited compilation of these individuals' comments about Judge Mata's father are clear extrajudicial evidence showing that Judge Mata had a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants. And the judge is basically like, yeah, that's rich. So applying an objective standard, not by reference to the affiant's subjective belief, this rule, the court carefully reviewed the compilation CD and considered in context each of the comments identified in petitioner counsel's affidavit. Given the seriousness of the allegations, the court has made best efforts to provide both the context and verbatim language of the various statements, although admittedly the audio of the compilation CD is very difficult to understand at times. They're statements by Hava Darby. So petitioner alleges that Miss Derby, who speaks between 0 and 40 seconds in the compilation, also made statements which appear to imply that Judge Mata told her dad that she intended to rule in favor of Clayton before the case was tried. The first video clip on the compilation CD depicts a virtual meeting among 9 participants with screen names, including one woman with the screen name Hava Derby. Miss Derby holds up her phone and makes the following statements. I ran into Judge Mata's dad in the parking lot afterwards and I asked him, like, well, what do you think? He was like, I got to show you something. Female voice. What? So he whips out these papers in his hands. And did anybody, I haven't been online really today, but did anybody, I saw kind of briefly that it was denied, this request of findings of fact and conclusions of law proposed findings. Male voice. That wasn't denied. That was not denied. Okay. So anyway, did anybody get a copy of this? He was saying, Julie told me this is just you, Dad, you got to read this and print it out, copy, unintelligible. So for purposes of deciding the Rule 6.1 motion, this court accepts that the scenario recounted by Ms. Derby might have occurred. Though Miss Derby appears not to be clear as to exactly what she is talking about, which I would agree, because I just read that whole thing and that was the first time I've ever read that paragraph or was aware of this conversation in that context. And I don't know what the F Gingras is talking about. This court finds that the fact that a trial judge might have told a family member that she was presiding over a case and might have provided a copy of a publicly available filing, e.g. the request for findings of fact and conclusions of law and proposed findings that was filed on June 3rd of 2024, which would have also been, I think, public record at that point, no? Neither proves by a preponderance of the evidence, which is the lowest possible standard, that the judge was biased or prejudiced, nor does it prove that she told her family member how she intended to rule before the case was tried. Now he starts talking about Dave Neal. As many of you know, Dave Neal was very famously there with like a taco truck or something, handing out scones or breadsticks, and doing Dave Neal stuff, reporting on it live with Megan Fox. They were there together. They were sharing microphones and stuff, and Lauren Knighty was there in the courtroom, providing, I think, the only video feed of the trial, doing her damnedest to make sure that everybody got their eyes on this case. And this is what the judge had to say about him. So petitioner's counsel affidavit further alleges that an individual named Dave Neal made remarks to signal to the person speaking that they should not disclose further information regarding the comments they claim to have received from Judge Mata's father, because her believed they would expose judicial misconduct and bias on Judge Mata's part, requiring a new trial if those facts were exposed. So there's the second video clip on the compilation CD, depicts a group of people standing under an awning. I remember that. I watched it live. The bottom left corner of the screen says Dave Neal Rush Hour Podcast. In the foreground, there are two men talking, one in a red shirt and the other in a hat, identified in the affidavit as Dave Neal. While the two men are talking, a woman in a hat approaches and joins their conversation. A woman on left in a black shirt chimes in, and a second woman on the right in a black shirt follows up. Male in red shirt. Judge Mata's dad was in the court with us. Dave Neal, Judge Mata's dad? No way. It's in the court in the side room where we were. Judge Mata's dad was sitting there. She did fantastic. Woman in hat at 51 seconds interjecting. I said, Harry, that's really nice. You want to be here to support your daughter? He said, oh, no. I've been hearing about this. I'm here for the circus. Group laughs as woman in the hat walks away. Dave Neal chuckling. Hold on. We don't need a mistrial. Oh, might as well just call 911. Why not? They already brought in the bomb squad. So the male in the red shirt, we could get him some scones. Yes, scones. I was waiting to get in. We just heard Dave Neal is a comic. He's like a literal stand-up comic. He does this stuff for a living. And so he's cracking jokes, and somehow that is tantamount in Gingras's mind to I don't know. What is that? That was evidence that somehow dad was in cahoots with the judge for some improper context or whatnot. It just, I mean, I guess it was a nice try. Oh, it goes on. So you don't look like the demographic. How did you hear about this case? And then he says, my daughter. There you go. Hey, that's and he was reading case files. I'm sure he was. I mean, he was probably a judge. I feel like it runs in the family. He did not tell me any information about her thoughts, and I was sitting right next to him. Oh, I'm sure. Yeah. So again, for purposes of deciding the Rule 6.1 motion, this court accepts that certain facts recounted by those courtroom observers might have occurred. For example, Mr. Howe might have informed an observer before the hearing that he heard about the case from Judge Mata. Mr. Howe might have told an observer he considered the hearing and additional goings on to be a circus. And Mr. Howe might have been reviewing paperwork related to the case. When viewed by an objective standard, Mr. Howe's alleged statements and actions do not prove, by a preponderance of the evidence, with that Judge Mata was biased or prejudiced, or that she told her family member how she intended to rule before the case was tried. This court also finds that certain statements made by the courtroom observers reflected nothing more than mere conjecture like Mr. Neal's statement that Mr. Howe was probably a judge, exactly. I feel like it runs in the family. The court further finds that the video reflects that Mr. Neal's remark, "We don't need a mistrial," after the speaker started walking away, was just in jest because he's a comic, as evidenced by his and the onlookers' laughter and his agreement with another bystander, and they should get him a scone. Court concurs with petitioner's counsel. Subjective belief that respondents' supporters gleefully celebrated Judge Mata's father attendance at the hearing. See Rule 6.1 motion at 12, and that the supporters' actions and perhaps even Mr. Howe's alleged actions can be perceived to have made a mockery of these proceedings. This court declines, however, to impute bias or prejudice to Judge Mata based on statements made by respondents' supporters whom petitioner's counsel characterizes as generally not honest or reliable about Judge Mata's father, or even statements made by Judge Mata's father himself. It is ordered that I am denying petitioner's motion for change of judge for cause. It is further ordered I am denying respondent's request for leave to file a supplemental affidavit of attorney fees and costs. It is further ordered I am denying respondent's request for this court to enter further orders pursuant to Rule 8.2a of the Arizona Rules of Professional Conduct. And it is further ordered returning this matter to Judge Mata to rule on all pending post-trial motions, so that one motion that she had already ruled on prematurely, well, that's going to get reinstated. And that is how you dunk on a clown. I thought that was pretty succinct. I said that I wasn't going to read the whole thing word for word, but I kind of ended up doing that. Oh, well, no, I started with the most juicy part of it, didn't I? I forgot to read all of this other part of it, but I think we got to like the meat of it. You know, the arguments regarding the two main issues, all of his allegations about reasons why Judge Mata was somehow biased, and the rest of this, like the first part of it, they're talking about procedural stuff. There's a recitation of the rules, the timeliness of the motion. I'm pretty sure he was timely. They're talking about a recitation of facts. It looks like there was a request for hearing, analysis of cause of change for judge, and then we got to the meat and bones of it. So 9 pages. Really, the last 5 pages were what we were looking for. And the entire thing was denied. And so what's next? So I have, there was a bar complaint, and give me 1 second, folks. So I am in contact with the person that made the bar complaint against Mr. Gingras. And she has in her hand, or he has in her hands, or whoever it is has in their hands, the written response from David Gingras. And she or he is in the process of redacting that. And I may be able to go over it here on the live, or I may not. Hey, folks, I think I need you to stand by for 60 seconds. Give me a second here. F, I've been muted this whole time, haven't I? Oh, where's Dominic, man, when I need him? I'm sorry, folks. I'm sorry. All right, I'm gonna start over. So listen, so this is Gingras's response. This is a response. It appears to be one of a series of emails that he's written going back and forth to people. This is a copy that the bar complainer has sent or received and sent to me. And so I'm getting all of this in real time. And folks, give me 1 second. I apologize, but I got to make sure of something before I do this. Give me 1 second. I'm going to mute myself again. I promise I'll unmute it when I come back. All right, folks, I'm back. All right, so we're ready. We're ready. I just had to make sure and confirm certain things before I started reading this stuff because I was getting a lot of text message back and forth. I want to make sure that I'm paying attention to what they're saying to me before I start going into stuff that they don't want me to go into. But I got some clarification, and so we're good. So this is an email that was sent in response to the bar complaint. I'll just go through it. So as a follow up to yesterday's emails, I need to add a couple supplements. And again, this is David Gingras. He's emailing Jackie Brokow and Jim Lee. I'm assuming that those are people associated with Arizona State Bar, and they are conducting their investigation in Gingras. So he's beholden to them. They're going to be the ones to determine whether or not he is going to be charged with anything or not. So what I don't have is the full, obviously, the full communication exchange. This is a response that was sent on August 8th. That was like last week in the morning, around the same time that we had, I think, went live with our recitation of the bar complaint that was filed against him. So this email starts, Mr. Brokaw and Mr. Lee, as a follow-up to yesterday's emails, I need to add a couple supplemental comments regarding the charge from Redacted. after or shortly before. The timestamps on Twitter are not necessarily reliable. My response to you yesterday posted redacted posted information about her bar charge. He says her, and she doesn't care if you know that she is a she. Bar charge on Twitter. I did not know about this at the time. I sent my response to you. I only learned about it yesterday evening. Screenshots of redacted tweets are included below, and a link to her post is here. You should be able to see this without a Twitter account, and then he posts a link there that I'm not going to click on. Note, this Twitter account, Tramp Stamp Lawyer, is a parody criticism account created by the JFC cult, which is focused on publishing negative information about me. And I want you all to know that this person that filed the bar complaint emphatically and loudly declares that she is not a member of JFC or the JFC cult or any other group claiming to have some kind of affiliation that David Gingras thinks he can define. She's an independent person. She brought this complaint all on her own. This is her own doing. She's not part of any JFC cult or whatever Gingras is saying right now. So he's wrong with respect to that. So before you ask, I have no idea what the significance of this term is, a tramp stamp. What a effing asshole. This guy is a cunt of the nth degree. I apologize for using the word cunt. He's just such a Weasley, stupid ass little schoolyard pith. He's a pith. He knows good and well what a tramp stamp is. That phrase has been in the public lexicon since 1782. I have no idea if it has or not, but everybody knows what a tramp stamp is. And the fact that he feels the need to label this in a sentence, in a reply in which he is being asked to explain his behavior to the Arizona State Bar, the fact that he's still throwing in these little pot shots here and there, claiming ignorance. Oh, I have no idea what the term tramp stamp means. He's just a clown of the highest order. What could I say, man? He's just such a dork. He's a dork. All right. Usually refers to a tattoo on a woman's lower back. I do not have any tattoos, nor does Laura, to my knowledge. In any event, I have never threatened whoever is behind this account. I am blocked from the following account. He has threatened literally everybody who's spoken negatively about him and Laura Owens in this case for months. How could he say that with a straight face? I went through hundreds of pages of examples where he was talking about you're going to be paying for Laura Owens horses when this is all said and done, and stupid comments like that. Name calling and you know, all of his choice words that he has for the JFC community, which, by the way, he attributes anybody that speaks negative about Laura Owens to be a part of the JFC community. He's done that for months now. It's no different here. And he's continuing to do it, you should know, through his correspondence with the Arizona State Bar. So the reason we know Redacted posted this is pretty simple. This tweet includes a copy of the bar's letter to her dated yesterday. Although she redacted her name from the letter, she did not redact the file number. Obviously, I have no issue with Redacted or anyone else posting truthful statements and fair criticism online. The problem is that he thinks that there isn't any fair criticisms of him that can be found online. Although, to be fair, I will be fair. When I had my initial email exchange with David Gingras and I asked him some pretty poignant questions about, like, for example, if she was so scared of Clayton Echard such that she couldn't trust him to show up to obtain results of an ultrasound because she was afraid of what he might do, then why would she be pursuing a relationship with this guy, or why would she do this, and that? And he said, you know what, to be honest with you, I ain't got no effing clue why, or something to that effect. There were some things that there's just not a defense for, and so he would own up to those things. So maybe that's what he's speaking about. But anybody that questions his genius historically has been criticized by him as being unfair or cultish or cult-like. So there's that. Obviously, I have no issue with, it's not so obvious, sir. Nor do I have any objection to them sharing matters of public record. That's how the law works. Although this is slightly ironic given that Redacted asked the bar for a protective order to prevent me from retaliating against her. As I indicated in my letter yesterday, I have no idea who Redacted is. I have never communicated with her, nor have I ever threatened her in any way. The first time I saw her name was when you submitted her charge to me yesterday. This leads me to my second point. I'm concerned Redacted may have misunderstood Mr. Lee's comments in his June 26, 24 email to her. In that email, Mr. Lee advised Redacted correctly that statements made to the bar are subject to an absolute privilege. This statement is, of course, completely true, and I have no problem with this. However, any suggestion that Redacted is wholly immune from suit just because she has also submitted a complaint to the bar is incomplete and potentially misleading. I'm concerned the reference to immunity in Mr. Lee's email may have caused Redacted to believe incorrectly that she is absolutely immune from suit for any public statements she makes on social media simply because she made the same statements to the bar. I don't think that letter even so far as hinted that that was the case, that her request for immunity was anything more than a request to remain anonymous. I don't think that there was any understanding on either side that that would mean a full-on protection from defamatory statements. So I kind of take that, having read Gingras's writings now for months, as a veiled threat at people posting bar complaints against him, because he knew that she was going to get this. He knew that people were going to see this. I feel as if he is trying to say here that anybody who files bar complaints against him may become the subject of some kind of defamation lawsuit in the future. Why else would he feel the need to write that? Because it benefits not the state bar. It doesn't really help his case much. If anything, it could be interpreted as another veiled threat to the person that filed this complaint to begin with, knowing that this was going to be sent or received by her as was promised in the other email that I read last week. That's his style, isn't it? Well, she's not intimidated. It doesn't sound like. Clearly, while I have no intention of suing her or anyone else, if Redacted posts false and defamatory statements about me on the internet, she would be subject to liability for... This reads like a cease and desist letter, doesn't it? Subject to liability for defamation, regardless of whether she also happened to make the same statements to the bar. I think it is very important she understands this, and I think it is clear she does not understand this. That was a conversation that nobody asked for, sir. That is not, honestly, I'm just flabbergasted. I'm like just in shock that you can be charged with explaining your behavior to the Arizona State Bar, and under the guise of protecting the general public from lawsuits, you make this veiled threat that if she posts defamatory shit, I'm going to sue the F out of her. I'm not planning on it, but I just want to remind her that if she does, and to be fair, I went through that entire complaint. All of that was taken straight from stuff that he authored. There was not a word in there that wasn't, I mean, there was words in there that were not written by him, but like 90% of it was his own written statements. But I don't know. Does he think that? I don't see why you would include these paragraphs, because it's not like the state bar was asking for it. They're not, it's not really relevant to their investigation. She was certainly not asking Gingras for legal advice. I don't know, man. Maybe he just made those comments in jest. You know, maybe he was just spitballing, or maybe it was intended to be a veiled threat to anybody that would dare pursue further bar complaints against this freaking guy. Maybe. I gotta say, though, I have yet to see anything defamatory against Gingras or Laura Owens from the coverage that's come out of even the most evangelic of JFC cult members. Is that even a word? I don't know. All right, let me let me continue with this. As I explained in my letters from yesterday, it's also important, Mr. Lee, and all bar staff to know the JFC cult is extremely dangerous, and they should be treated as such. That, sir, is a free speech argument. Honestly, that's what it is. That's what it is. That's what it is. I've seen those kinds of arguments. You know who people talk about being extremely dangerous? The JFC cult. Now that's his characterization of people that disagree with him and are unbelieving of Laura Owens' allegations. We've seen language like that promoted against white nationalist groups, the Proud Boys, the KKK. What's that other one? The new one that likes to Antifa. I've seen that kind of rhetoric spoken out against those extremist organizations. The fact that he's attributing that language to this term that he coined, the JFC cult, is a little bit much, putting it mildly. In addition to making false statements to you, I read the whole effing complaint, man. What was not true about what was submitted? Because it all appeared to be blog posts and Twitter posts and emails and communications direct from stuff that he wrote directly. They weren't making that shit up. They copied and pasted, man. And so, so in addition to making false statements to you, which they believe they can do with impunity, they are huge fans of doxing anyone they dislike. They will typically publish any and every document they can find which supports their narrative or which appears to denigrate myself or Laura or anyone else they dislike. Well, to be fair, I think that what all of the pleadings that are public record and therefore published by the courts have been talked about. And every time he submits a motion, people that support Clayton Eckert have posted his pleadings and talked about them pretty fairly. I think I've done it. I have given him the benefit of the doubt as much as I possibly can. I have even given him credit where it was due. I even at one point stated that, hey, we really need to look more into this Judge Mata thing, mischaracterizing evidence. What is that about? And then we did look in it and said, oh, it's just a whole lot of nothing. But yeah, you found one that was potentially, I don't, he has the problem with Gingras, man, is that his head is so far up his ass. He just lives in his own reality. He's lost his ability to be objective about anything regarding this case. And when you lose that as an attorney, you are in a dangerous place representing your client because you can no longer. The whole point of being an attorney, the whole reason why you hire an attorney is so that you have an objective, non-emotional person pulling for what you're seeking. And they're going about it in ways that are based in law and fact, not on speculation and conjecture. Every motion that I've read from this guy has been based on speculation and conjecture, and the judge called him out on it. Judge Fritz. I'm surprised she didn't call him out for his choice of language in mocking Judge Mata for mentioning that, I don't know, the way that he mocked her when her dad was there. But, at this point, you got to take it with a grain of salt what he says. He's reached a level now of distrust in the things that he writes where you're not so much looking for what he's lying about. You're looking for the nuggets of truth that might be shrouded in all of his lies. Much like a politician, that is his style, that is his MO. So, document Laura or anyone. Okay, so because of this, I'm confident Redacted and or other cult members will publish any and every document relating to this matter in an effort to make it appear falsely that I am guilty of some wrongdoing. Hey, sir, I am an attorney. I've been practicing for 10 years, and I have it on good authority, which is primarily my own opinion, that the way that you handled this case and the way that you conducted yourself in public, the way that you've conducted yourself online, the way that you've represented your client is beneath the standard that is required of an ethical attorney. It's my opinion. Am I wrong? I might be. Maybe I'm wrong. Maybe I'm wrong. Maybe time will prove me wrong. But in my opinion, I have severe questions about the way that he's conducted himself, the way that he's communicated with the parties in this case, the way that he has communicated with certain people that have interest in the case, the way that he has characterized them as cult members and pond scum and all of these things, the way that he's tried to, in the most bougie way possible, try to make fun of people in their professions, trying to make pennies off of YouTube while I was over here in the French Riviera, whatever he was on vacation, because he's this 20 years plus attorney. He's even trying to like big boy Woodnick, who kicked his ass in court through every orifice by saying that he's never had a published case in whatever LexisNexis. I looked up his name. You know how many results pop up? 0, except he managed to kick your ass in court. So there's that. So what does that really have to do with anything, sir? Because his big claim to fame is some kind of civil lawsuit from like 10 years ago, and he's still living off of the merits of that. And good for him. He made an appearance on Dr. Phil once. I'm not sure what else of note he's done, but I also know that he's got a criminal record, DUIs or whatnot. He's not a saint, and I so don't care about that kind of stuff. I don't judge people on the merits of they had shitty times in their life where they did stupid things, but the way that he's conducted himself as a lawyer, just as a colleague, and he's not my colleague because he practices in Arizona, I practice in California, but as a lawyer in America, I have questions about, it would make me nervous to practice and conduct myself the way that he's conducted himself. Hey, maybe he knows better than I, but I would not, in good conscience, be able to do that and feel good about myself, sleep at night, feel confident that I'm doing the best for my client, that I'm serving their best interests. I just wouldn't, man. Is that a personality flaw? Is it a character flaw? Is it something else? Is it something much more simple? Is he trolling us? Is he trolling the legal community? Is he trolling JFC members with this response to the bar? I feel like he kind of is. But I also think it's a combination of all the other stuff too. All right. So for that reason, I would respectfully ask that Mr. Lee exercise caution in this future correspondence with Redacted. He should be aware that anything and everything sent to Redacted will be posted online by her, not by me. At the very least, in future correspondence, Mr. Lee should also inform Redacted that Supreme Court Rule 48I does not provide immunity from claims arising from the publication of false and defamatory statements on social media or anywhere outside of the scope of what the rule protects. Again, with the way that I interpret that is as a veiled threat to people wanting to bring bar complaints against this effing guy. Did I skip over anything? Confident publisher? Yeah, I did not. So one final note. In my letters yesterday, I suggested it is likely the bar has received or will receive many additional complaints about me relating to the Owens v. Eckerd case. I realize that statement probably sounds paranoid, but there was a very specific reason for that remark. Well, I agree with him with that anyway. He probably is going to receive many more bar complaints, which is the reason why I felt like the bar complaint that I read on my show last week, I felt like it's probably not going to go anywhere because, I mean, he already got basically, there was already a complaint made by Dave Neal for similar things. And so to the extent that those issues overlap and they appear to have resolved all of those things, I just don't feel like more of the same is going to do anything. Although there is this thing now where there's the thing where he may have shared stuff that was ordered to be under seal. So that is a legitimate issue that the bar might have with him. Do I think that he's going to be disciplined with anything that's going to jeopardize his career? No, I don't. He's going to get a slap on the wrist. I don't think this is going in unless he just like self implodes the way that Laura Owens did on the stand. I don't think that he's going to get, I think that this is honestly just going to go away. As much as I can say that I disagree with his conduct, I don't believe that the bar, if they haven't already done so with respect to some of the stuff regarding his writings and his publication, if they haven't done it by now, I just don't think they're going to, unless he just keeps doing it. And then maybe, you know, and he's kind of cleaned up the way that he is reacting to some of this stuff. I haven't looked at his Twitter in a while. As far as I'm aware, he has not really posted any crazy tweets lately. I'm going on his Twitter page right now to see if there's anything updated on there. There's this one from April 4th. There's a tweet from April 4th. Yeah, there's all that stuff. April 5th, April 7th. Oh no, that's not. Yeah, there's nothing new. If anybody knows of anything new, then let me know. But I don't think that, honestly. There's a whole lot there. Let me get back to this email. Wrap this up. I just heard a beep. Hey, what's up, Bruce? Dave reported live on June 10th with the Society of Professional Journalism number. Cool story, Gingras. Dave, I got to read that again. Dave reported live June 10th. Oh, Dave reported. I feel like I'm reading this with the wrong inflection. Dave reported live June 10 with a society professional. Oh, I get it. I get it. Yeah, I agree. That was kind of stupid. I remember watching that on Dave's live when I was in Hawaii. I think I remember independently that entire exchange. Let me finish with this email before I get further distracted. Let me make sure that. Hey, cat lady, how you doing? Your mic, Elaine. Is that like an joke that I'm missing? I feel like it might be. Thank you so much, cat lady, for the 2. I really appreciate you. Okay. All right. So, over the last several months, Mr. Neal has published hundreds. Okay. One final note, my letters, I realize the statement probably sounds okay. One of the primary leaders of the JFC cult is a YouTube content creator named Dave Neal. Mr. Neal claims to be a journalist. He is not. There's not like you don't need to be licensed to be a journalist. If somebody wants to do the work of a journalist and call themselves that, they're welcome to. And if they can make money doing it, I guess that makes them a journalist, doesn't it? Furthermore, I think it makes them a professional journalist. But what do I know? Oh, I'm getting stuff on the. Oh, there's new stuff. There is new stuff. All right, I got a new something. Okay, so I have another email I'm going to read for you after this one. So over the last several months, Mr. Neal has published hundreds of hours of. I skipped something, didn't I? Mr. Neal's primary source of income is posting self-created videos on YouTube. That is not his primary source of income. Dave Neal is a stand-up comic. He has a Patreon. He has a podcast. He's on like a dozen different carriers. One of them is YouTube. His main source of income, I promise you, is probably not YouTube. It's just not. Mr. Neal is also friends with Mr. Record, and he is friends with Mr. Record, and he personally attended the trial on June 10th. Mr. Neal even set up a tent outside the courthouse where he live streamed for several hours before the trial. I don't know why this is pertinent information, but he's including it in his response. So after the last several months, Mr. Neal has published hundreds of hours of videos about Laura and me, among other things. Anytime a new pleading is filed in Owens v. Eckert, Mr. Neal will obtain a copy from the court. Honestly, don't think he has to obtain it from the court. He could just get it online because it's just there. Other people obtain it from the court and then they widely disperse it because this is all over Reddit. This is all over different wikis. This is all over the place. I have never had to pull any documents from the court because they're just so widespread. And I'm not getting them from Dave Neal. I don't think that Dave Neal is independently getting them by himself because, and even if he was, all you had to do is go to the type in the case name, the case number, whatever, download whatever document has been made public, and you're fine. So Mr. Neal earns money. Okay. He literally posts new videos about Laura virtually every day and sometimes more than once a day. This is slightly reduced since the trial in June. It's reduced a lot, actually. Several months ago, Mr. Neal submitted a complaint to the bar about me. That complaint was later dismissed. Despite this, Mr. Neal made videos discussing his allegations against me, and he posted this video, which, in my view, encouraged other people like redacted to submit additional complaints. He links to that video. I think probably most of you have already seen that video. Obviously, I recognize and respect my ethical duty to cooperate with any investigation you may perform. I have always complied with that duty, and I will continue to do so. At the same time, I want Mr. Lee to understand that this is not a normal situation. The JFC cult has anywhere from 2,000 to 5,000 active members or more, and they are absolutely obsessed with destroying Laura and anyone else who stands in the way of their goal. This is why I would expect the bar to receive numerous additional complaints if you have not already. This is not an indication of misconduct on my part. It is simply an unfortunate reality of what happens when you're dealing with an angry cult. As always, I'm happy to discuss further. I'll tell you what he's doing. He's trying, very interestingly, he's not addressing his behavior. He's not showing any remorse for any of his behavior. He is simply trying to disregard the complaints as a crazed group of cult members who are in the process of trying to destroy him and his client's life, and he should be absolved of any wrongdoing. That appears to be what he is going on about. So there's more to this. There's exhibits. That's the Dave Neal video that he had mentioned. This is, what is this? Oh, I guess probably on Dave Neal's video, a screenshot of him talking about the complaints. Responsive note. Oh, yeah, he's talking about one of Gingras's motions. Further attached is, Tramp Stamp Esquire. David S. Gingras is officially under investigation at the Arizona bar. So there was that tweet. That's a great picture of if Gingras had a beard, I could see him with that look. August 7th. So he thinks that this is something to talk about. I guess he's highlighting the part where in these photographs, they were photoshopped to include Arizona State Bar stuff on there. And then he's talking about an email. What is this? File number, respondent David G. We received your correspondence regarding possible ethical impropriety by the above named lawyer. That's the letter that I think we had already gone over. Yeah, I think it is. This is an email from Jackie Brokaw. I guess this is what he was responding to. Attaches a letter from Senior Bar Counsel James Lee regarding the above referenced matter. Also attached is a protective order that was issued in this matter. And, well, I don't get to look at that. So that was that one. And now I have another email that I'm going to go over right now. Oh. Right. Let me just embiggen this a little bit. So, Ms. Brokaw, attached is my response from the charge from this case number. As before, I've CC'd my client, Laura Owens, on this response since the allegations relate to her case. Although Ms. Owens' consent is not required here per this rule, she has nevertheless reviewed this response and has given her prior informed written consent to its contents. As I indicated in my other response sent earlier today, Ms. Owens is happy to discuss this matter with bar counsel and to provide any additional information you or he may need. Laura's phone number is redacted, and she is also easy to reach via email because address CC'd here. Laura has read the charge from redacted and is familiar with both the complaint and the details in my response. Per ER 4.2, I don't believe her bar counsel needs my consent to communicate directly with Laura. I assume such contact is otherwise authorized by law. If my consent is required, please accept this as my consent to communicate directly with Laura. This consent applies to, okay. Good morning. Attached is a letter from Senior Bar Counsel James Lee regarding the above referenced matter. Also attached is a protective, okay. What do we have here? So this is an email dated August 7th from James Lee. This is the complaint. Or no, I guess this is addressed to him. Just, Dear Mr. Lee, this letter is in response to yours dated August 7th, 2024, regarding a complaint you received from redacted. As explained below, the complaint has no basis whatsoever, and it should be promptly dismissed. After reviewing the charge from Redacted, I need to be honest. Her allegations are largely, if not completely, unintelligible. I have no idea who this person is. I have never met Redacted, so I have no personal knowledge regarding her allegations except to the extent they are described in the charge you received. Interestingly, I read that complaint. And one of the things that I remarked in reading it is that it was really well done. I mean, it pretty clearly articulated exactly what she was trying to say, complete with exhibits, and I knew exactly what she was saying. He was behaving himself with conduct and writings and in a matter unbecoming of a respectful attorney who's been practicing in the state for 20 years, who is in charge of protecting the general public from behavior such as that. And there was hundreds of examples and whatnot. So having said that, I will do my best to decipher her allegations and respond as best as I can. That's his style, isn't it? He does the whole Trump thing. He's got Trump's style down to a T. You have to let out some kind of an insult first, insult the person opposing whoever's on the other side 3, 4, 5 times before you get into some half-assed retorts to whatever the allegation is. That's Trump's style. That's his style. Because the charge contains multiple, I'm not trying to knock Trump. I'm still political free agent. I'm just saying, I recognize the style from somewhere, and Trump wrote the book on that shit. So because the charge contains multiple repetitive statements which appear to raise the same general points, I will try to lump these together and respond to each group in turn. To help provide some context, as I explained in my response to the charge from Dr. Daines, I represent a woman named Laura Owens with respect to a single case, Owens v. Eckerd, with the case number. That matter involved a petition to establish paternity filed by Laura, pro se, on August 1st, 2023. In short, Laura claimed she had a one-night stand with a man named Clayton Eckerd, who was formerly the star of the reality TV dating show The Bachelor. In her petition, Laura claimed she became pregnant with Mr. Eckerd's child or children, and she petitioned the court to establish paternity. Laura claims she had a miscarriage in mid-October or early November 2023. As a result, she filed a motion to dismiss the paternity action with prejudice on December 28th, 23. Confusingly, it's not confusing. They give you a written explanation. The Superior Court granted the motion to dismiss, but then allowed the case to proceed to trial on June 10th, 2024. That was because of sanctions and multiple pending issues. The trial was supposedly focused on Clayton's request for sanctions based on his allegation that Laura faked being pregnant. Obviously, Laura strenuously denies that she ever faked being pregnant, despite the evidence presented at trial being to the contrary. And her written admissions and oral admissions that she altered ultrasounds and such. I first appeared in Laura's paternity case on March 25th, 2024. Prior to this, I had no involvement of any kind in the dispute. Also, Laura was represented by other counsel in the paternity case for parts of December 23 through mid-March 24. Importantly, Laura also had a separate matter involving Mr. Eckerd. The other matter was not a paternity case. The other proceeding involved a pro se petition for an order of protection. In short, in the OOP, Laura claimed Clayton harassed her by posting an embarrassing, partially nude photo of her on the internet after a hearing in late 2023 at which Laura would. Is he talking, chat? Is he talking about the pregnancy photo where she's showing her belly? I don't ever remember seeing a partially nude photo of Laura Owens ever. Am I missing it, or am I crazy? That's what he's talking about. Son of a bitch. Hey, Ann Tuttle. That's such an awesome name. Ann, you are an awesome. I declare you to be an awesome, and I appreciate you. What's up, Pam? Thank you so much for the 20. You were on mute. She was telling you, hey, Pam, when you called me, that's when I figured out that I was on mute. That is why you are the boss moderator over there in the chats. And you have my respect. As in the words of Ann Tuttle, you are also an awesome. I love you guys, man. Let me continue with this. So he's talking about the OOP, and he's being disingenuous at best. It wasn't a partially nude I guess if you consider an exposed pregnant belly to be partially nude, usually when people refer to partially nude anything, it's, in the words of the Supreme Court, to appeal to the prurient interest, which that would not be, I don't know, for some people out there, some people got fetishes or whatnot. So, after a hearing in late 2023, the court found in her favor and granted the protective order against Clayton. That was because Judge Duty didn't understand much about how the internet works and, you know, whatever. I've had my objections to that. No harm, no foul, I guess. After the OOP was ended, case ended on March 26, 2024, Clayton's attorney filed a motion in the OOP case requesting relief from the order based on fraud. In short, Clayton's attorney claimed Laura was never pregnant and thus ineligible for a protective order, which generally requires a prior parental or romantic relationship between the parties, which they had, at least for a day, at least for a 15-minute BJ or however long it took. They had the requisite relationship for an OOP. Otherwise, Laura's wouldn't have been granted. What is he talking about? All right. So Clayton's attorney claimed Laura's not okay. Not only did he claim that she wasn't pregnant, but he submitted compelling evidence to suggest that she was never pregnant. They kind of go hand in hand. So to help respond to that issue, I entered my appearance in the OOP case on April 9th, 2024. However, the OOP case was later consolidated with the paternity case, so I filed nothing further in the OOP case after my initial appearance. So turning to the specific claims and redacted's complaints, she appears primarily focused on the paternity case between Laura and Clayton. That was not my read of the focus of that complaint. As I read the complaint, my understanding of the focus of the complaint, it was based on the conduct and veiled threats and actual threats by David Gingras against certain members of the community that was against Laura Owens' claims, her allegations, or whatnot. In addition to that, the other aspect of that was there were specific instances where David Gingras, for whatever reason, felt it prudent to release evidence that was ordered under seal by Judge Amato, who, by the way, is still his judge, in case he forgot, by virtue of Fritz slam dunking on Gingras with balls in his face. So, turning to the specific claim, so based on her language, it is clear she is a member of the JFC cult, which I previously described her. I just don't give a shit about this term anymore. JFC cult doesn't mean anything. JFC cult just means anybody that's not him or Laura Owens at this point. He's just completely, he talks like that. What are you going to do? Which I previously described. Her complaint is essentially nothing but a copy-paste list of JFC cult talking points, which have been shared online by other cult members. I disagree. That complaint was a copy and paste of his specific online post to the entire universe that was not limited to JFC cult people, unless his JFC cult people is basically means anybody that challenges anything that he says, which I'm sure that's what his definition of it would be. In case this isn't obvious, it's not obvious. The JFC cult sees me as a threat to their goal of obtaining justice. Nobody sees, I don't think, does anybody out there see Gingras as a threat anymore? Is he a threat to anybody? Who's he a threat to? He's lost every effing motion that he's brought in open court. He hasn't brought one successful defamation complaint against anybody related or associated with this case. He hasn't even managed to appropriately bring copyright strikes against YouTubers covering this case. And to be fair, I don't know if he's ever I don't think he's been the one that has submitted copyright strikes. Today, I learned that Laura Owens was submitting copyright strikes. But all I'm saying is I haven't seen Gingras win anything with respect to this case. Usually to get people to make people feel intimidated by your prowess as a lawyer, you got to win. And he doesn't have a very good track record from what I can tell. Nutrition. How do you say your name, miss? Nothing like it. Says he's a threat to Laura. That's about it. I've been saying that for months now. I really want her to get, I wanted her to just get different counsel, just get a normal lawyer that's not going to do this shit. There's somebody that's so above the fray to not get her entangled with this stupid shit, man. If this was any other attorney, I feel like this would have died so much faster. But because Gingras has just basically nuked the entire case with his bullshit, here we are still talking about it months after trial. What could you do? Going on with this. So, having said that, to the extent I can understand Redacted's claims, here is my response to each point. Releasing sealed documents. That was kind of the big one. Redacted makes several references suggesting I somehow violated a court order by publishing sealed or confidential information. Here are a few general examples quoted from her charge, all of which are completely conclusory and supported. Violating the rules of releasing sealed documents without court permission, releasing sealed documents without court permission, breaching confidentiality and contempt of court by unauthorized release of sealed documents, instances of releasing sealed photos, medical records, and videos on social media. Hey, you guys want to see something? I had supplied this person. They had just kind of asked me offhand, like, is there any case law to support the complaint, basically the bar complaint about releasing sealed documents? And I had listed a whole host of case law that supports that, but it was based out in California rules of court. But you could do the exact same thing with Arizona, which is where we are litigating, where this case was litigated. And so if we were to go back and give me a second while I pull this really quick. Give that a couple seconds. It's coming. But there's case law and statutes that specifically say that you can't do what he's alleged to have done. Specifically in those instances. I guess there's another bullet point, a video depicting Clayton Ecker's deposition. So as I previously explained in response to the charge from Dr. Deans, there is no court order sealing anything or otherwise preventing the disclosure of pleadings, transcripts, depositions of records and filed in the case. This is a popular JFC talking point, but it is completely false, except, well, give it a second. Except there's case law that speaks directly towards not being able to do that very specifically. On the contrary, and as I previously explained, while Laura was representing herself pro se, she filed a motion on September 14, 2023, asking the court to seal the entire record. That request was denied by minute entry order dated October 18, 2023. After Laura retained counsel, her attorney re-raised the same privacy arguments in a motion entitled Motion for Confidentiality and Preliminary Protective Order, filed on January 17, 2024. A copy of this motion is attached as Exhibit A. That motion expressly asked for an order allowing depositions and other related material. He might be right about the deposition stuff to be marked confidential and protected from public disclosure. And then he cites this line, that any party depositions in this manner, the protective order also seeks that any party depositions in this manner, if deemed appropriate by the court, are designated as confidential until either party requests that the court make an evaluation into whether parts of the deposition or the deposition in its entirety should have the confidential designation. That was the proposed protective order. The order entered by the courts. The court has received and considered the motion filed on January 17th. It is ordered denying petitioner's motion for confidentiality and preliminary protective order filed on January 17th. I thought that there was a stipulated to agreement to seal records. Am I misremembering? I feel like I'm misremembering this. Well, I'll tell you what, if this order is legitimate and there was nothing that came after it, then it's pretty hard to argue that if this was what was requested in terms of depositions and everything. Does this include medical stuff though? Governmental information remains confidential. Counsel protective order that seeks any party depositions if deemed. I guess it's just to the deposition. I don't see any mention in there about medical records. Maybe that's where the confusion is. By the way, Arizona Rule of Civil Procedure 26C emphasizes the responsibility of the filer to redact sensitive information. I just lost my place. If you wanted to know what the case law was regarding sealed documents in the state of Arizona, there's Bourne versus Banner, University of Med, CTR, Phoenix LLC. It's a 2022 case. You can find it on Lexis. There's this other case, In Re, Arizona Rules of Civil Procedure. It's a Supreme Court case out of Arizona dated September 2nd of 2016. It's not a published case, but it deals specifically with that issue. Arizona Supreme Court Rule 123, access to judicial records of the state of Arizona, effective January 1st of 2024. In Re petition to adopt amended local rule. There's another Arizona rule, CIV-P54, sealing and unsealing court records. Those are the rules that they are dealing with. I'm literally doing legal research right here on the fly. So this is the rule of court, Arizona Rules of Civil Procedure 5.4. Generally, unless authorized by statute, rule, or court order, no document may be filed under seal in an unsealed civil action. Definitions: document, it just goes documents. Order permitting a document to be filed under seal, generally on motion. Well, this is talking about filing stuff under seal. This doesn't really talk about. I'm not going to try to do legal research on the fly during a live, man. That's a bad idea. I was trying to go over. I know what the California cases are. The Arizona cases I've never studied, and so I'm not going to try to do legal research on the air right now. So, aside from these two separate motions filed by Laura asking the court to seal the record and allow parties to keep discovery materials confidential, both of which were denied. Clayton never asked the court for similar relief. He never moved for, nor did the court ever grant any order restricting the publication of depositions or any other case-related documents. There simply is nothing in the docket that would even remotely support such a conclusion, bearing in mind, even if such an order existed, which it does not, the Arizona Supreme Court has previously determined a trial court cannot lawfully prohibit the publication of matters occurring in open court. Any such order is void, except if there are records that were required to be sealed by prior orders or by the nature of privilege, then that rule doesn't really matter. Then the fact that you introduce a document in an open court setting could subject you to sanctions or bar complaints, which is what we're dealing with right now. This probably explains why the trial court repeatedly denied Laura's request for confidentiality, privacy, and why the court specifically rejected a request to keep deposition transcripts confidential. I think part of that was probably because it was already out. But that doesn't really apply to medical documents, though. In fairness, there was a single sentence buried in a minute entry order issued in February 2024 before I appeared in the case, which seems to reflect some sort of informal agreement. Yes, this is what we were talking about. This is what I was misremembering. Thank you, Gingras. Between the parties not to publish medical records disclosed by the other party. But in this instance, Clayton never disclosed any medical records of any kind. The only medical records at issue in the case belonged to Laura, and she chose to publish them to respond to false statements made by JFC Colt Clayton or his lawyers. I think that Gingras is being slippery enough where he might just get away with it because, I have to read it again. I have to read that motion again, but he might have a point. He may. Witness tampering, threatening to have witnesses arrested. That was kind of the big one that we were talking about last time as well, wasn't it? Cindy Brown says, judge said either side, no more medical records, period. Yeah, I got to read specifically what the judge said because what I just read was Gingras's characterization of that statement. But if in the plain language, it was a clear prohibition against releasing medical documents on the part of either side, because there's an argument to make that even though those were Laura Owens' medical records, they necessarily implicated Clayton Echard as being potentially involved, because it involved paternity tests that may or may not have been related to a biological child of his, which is why the judge probably just shut the whole thing down. I got to read word for word what that order specifically says. Dr. Dean's testimony is medical info. Yeah, but she's also an expert that has been vetted and all of that. She's allowed to give her expert testimony. There's exceptions to all of that. And a lot of what she had testified to was specifically just kind of public knowledge stuff. Also, they litigated specifically what she was going to say. They already went through motions about what they were going to say. They had vetted her, so that's not really the same thing. So, witness tampering, threatening to have witnesses arrested. This is another popular JFC cult talking point. They claim I committed witness tampering because I threatened to have a witness arrested. Here's what actually happened. Oh, I'm so curious. This is what I've been waiting for the whole time. So during the course of discovery, Clayton disclosed that he intended to call a trial witness named Mike Maricini. Mr. Maricini is an ex-boyfriend of Laura who resides in San Francisco. Laura dated Mr. Maricini for approximately 2 years in 2016 to 17. The entirety of Clayton's disclosures regarding Mr. Maricini are shown here. This witness is expected to testify about his prior interactions with petitioner, her alleged 2 pregnancies during their relationships, and the subsequent litigation. As I would in any case, while preparing the case for trial, I reached out to the contact person listed for Mr. Maricini, a lawyer named Randy Sue Pollack. I know what he's about to argue. It's the same stupid shit that he argued at the beginning of the start of on June 10th at trial, about how he was surprised that Mr. Maricini was here because of stuff, to ask if I could interview Maricini to learn more about his expected testimony. After speaking with Ms. Pollack, she told me she had never heard of the Owens v. Echard case and that she did not believe Mr. Maricini would appear at trial. She did not believe. But her statement that she didn't believe, how is that even relevant? If she's not involved in the case, doesn't know about the case, why would her opinion about whether or not he's going to appear even be all that relevant? I asked Ms. Pollack to confirm this to me in writing. Mr. Gingras, my client, will not be testifying. Randy Sue Pollack. All right. My questions for that is, did this Randy Sue Pollack know that her client was subpoenaed? And if, now this is Gingras's representation of the conversation. If her representation was, I mean, I don't know anything about Owens v. Echard case. I do not believe Mr. Maricini would appear at the trial. How is that some kind of authentic statement that, oh, he's definitely not going to be there, if she's not even aware of the subpoena? I'd imagine had she known of the subpoena, he might have given him a different response. But at this point, I'm speculating because I have no idea what Gingras represented to her, what she represented to him. So a few weeks later, just days before the discovery cutoff, Clayton's counsel informed me that, in fact, contrary to Ms. Pollack's written representation to me, Mr. Maricini would appear and testify at trial. You know, if I wanted to know if certain witnesses were going to testify at a trial that I was going to litigate, I think that I would specifically ask the trial attorney, not some other attorney who represented a potential witness in some other litigation from years ago. That doesn't make any sense to me. I don't know, man. Hey, this guy's the expert, isn't he? He's been practicing for 20 plus years. I've only been practicing for 10. So I don't know, but I think that if you're trying to gauge whether or not a witness is going to testify, you would ask the attorney that's going to call him as a witness in the first place, that lists him as a potential witness on the witness list. That's what I'd ask, but that's just me. I try to be as efficient as possible, you know? So in response, I explained that there were several problems with this. First, Clayton had failed to disclose anything about the expected substance of Mr. Maricini's testimony. Second, I noted Laura had a current valid DVRO issued against Mr. Maricini by the San Francisco County Superior Court and that this order did not contain any exception for in-person testimony, nor does it need to. Because of all the reasons that were stated in court, there's literally rules of court that permit for somebody who has a protective order against them to appear, to testify, and give testimony in a case where relevant. But anyway, he's actually making this argument to the state bar, so I guess. Where did I leave off? Third, I explained that under federal law, this wasn't a federal case. I'm not sure why federal law would matter. The Violence Against Women Act, or VAWA, it would be a serious federal crime for Mr. Maraschini to engage in interstate travel for the purpose of violating a DVRO. Oh boy, he's nothing if he's not creative, isn't he? Yeah, this is the VAWA statute. Fourth, I explained that, and he even cited it. I explained that the California law DVRO could not be modified or ignored by the Arizona courts. VAWA expressed required the Arizona court to enforce the California DVRO as written. See 18 U.S.C. 2265. Despite raising those concerns, I told Mr. Woodnick I would be happy to work with him to obtain permission from the California court that issued the DVRO so that Mr. Maraschini could testify. He doesn't have to work with anybody. He could just not raise the issue, knowing that there's going to be bailiffs and law enforcement on the ready in case anything happens, and deal with it that way. The fact that he went about it the way that he did was for no other purpose than for witness intimidation, and he knows better. Come on, he's not a second year. He's not a second year attorney. The only condition was I asked Mr. Woodnick to comply with his disclosure obligations by providing me with the information regarding Mr. Maraschini's anticipated trial testimony, which Mr. Woodnick was already required to provide pursuant to Rule 49 of the Rules of Family Law Procedure. Mr. Woodnick rejected that request, leaving us at an impasse. But you know what else? He didn't even call him as a witness. Maybe that was why. He's not required. Look, if at the time he wants to testify at stuff the way that most judges deal with it, if you have some objection, all right, well, give me an offer of proof what he's going to testify to. If it's so far out of the bounds of what was pled in the pleadings, it's such that it's not relevant in the case, then, you might be able to block a person from testifying. But insofar as what he had to say was within the spectrum of what has already been pled and what has been argued about for, I think, a year at this point, just about. Pretty close to a year. It's all fair game, man. It's all relevant, and he was on the witness list, so you know that he's an ex. You know exactly who he is. There's a very limited scope of things that he could testify that would be relevant anyway. So it's not like there's this huge surprise. For example, there wasn't going to be brand new allegations for which Laura Owens would face additional sanctions or consequences. She was on trial for what she was on trial for. The sanctions as her experience with Eckerd had led her down. I guess Maraschini would have been, if anything, maybe a propensity witness to state that, hey, she tried to do this with me as well. Try to get OOPs and DVROs and make false allegations and try the pregnancy thing, whatever. Some kind of propensity argument about, I'm not the only one that she's done this to, there are others. It was a propensity argument. He would have been a propensity witness. But with 2 hours, you don't have time for all of that shit. You got to get your stuff in, and you got to get out. And that's exactly what happened. So he was on their witness list. He was subpoenaed. Furthermore, Maraschini, as the recipient of a court-ordered subpoena on which it states that he must be present in court on this date and time, must be there under threat of contempt of court, of course he's going to be there. He's legally ordered to be there. The restraining order is just not. It doesn't pass muster as a valid argument. It's a creative argument, but it's an argument that a law school student would make. Like they would make that argument and they'd be so proud, like they said something, but it's, oh, actually, dipshit, there's rules of court that deal specifically with that issue. Despite raising those concerns, I told Mr. Woodnick I would be happy to work with him to obtain. I read that. So after I was unable to reach any agreement with Mr. Woodnick, I filed an emergency request for a hearing with the trial court so these issues could be discussed. That request was denied without explanation because it wasn't a valid argument, I admit. Usually emergencies require emergencies, but the fact that there wasn't a legal basis for what he was arguing, I guess, is why they would have denied it. In order to preserve the issues, on June 3rd, 2024, I filed a pretrial statement. Just because you make incorrect legal arguments doesn't mean that, oh, see, I was trying my best. I was, you can't protect your bad actions just because you may have made incorrect legal arguments to the court by virtue of an ex parte emergency hearing. And in the process, use that and disguise your attempt to intimidate a subpoenaed witness in this case. That's basically what he's trying to do. In the pre-trial statement, I explained it would be a crime for Mr. Maricini to violate California. We've heard this argument and nobody agrees. Accordingly, if Mr. Maricini appears at trial without permission from the California court that issued the original order, he will be committing a crime and will be subject to arrest pursuant to ARS 133602. This issue has been reported, blah. So there's absolutely nothing unethical or inappropriate about any part of these remarks. But before I get there, give me 1 second. Let me do this. Hold the line, folks. I'm doing something. All right. And all right. So we'll see where that is going to go. Let me do this. Am I still sharing my screen? Yeah. Okay. All right. So it says there's nothing wrong with it. And the order further contains exactly the same warning that redacted points to as the alleged witness tampering. It notes Mr. Maricini is subject to arrest for any violation of the order, and interstate travel for the purpose of violating the order may result in him being charged with a federal crime. Clearly, there is nothing improper about me providing the same warning to Mr. Maricini or his counsel that the DVRO contains. And then he lists this printout, which is what you would find on a California or I guess a restraining order, any restraining order, I guess. Just warning you that, hey, if you violate your restraining order, bad things can happen is essentially what that says. But this is straight from Lexis. Yes, you can appear at a hearing in Arizona when there is a domestic violence restraining order against you if you are subpoenaed to testify where the victim will also be present at the hearing. In Arizona, a subpoena compels a person to appear and testify at a proceeding, including a hearing, trial, or deposition, unless excused by the subpoenaing party or a court order. The rules of civil procedure, and this is in the state of Arizona, indicate that even if you file a motion to quash or modify the subpoena, you must still attend and testify unless excused by the party or attorney serving the subpoena, meaning Woodnick would have had to quash it or excuse it, not Gingras. He had no authority to do that. By a court order, and there's a case in Arizona Rules of Civil Procedure 2016, Arizona Lexis 259. Furthermore, the Arizona Rules of Criminal Procedure allow for the subpoenaing of witnesses, and there is no specific provision that exempts a person from appearing due to a DVRO. And that's Arizona Rules of Criminal Procedure 5.1. Right to a preliminary hearing, waiver, continuance. The rules also ensure that both parties have the opportunity to be heard and to present evidence, which includes the right to call and examine witnesses. However, it is important to note that the court may take measures to ensure the safety and protection of all parties involved, including the victim. This could involve specific arrangements or accommodations during the hearing to comply with the DVRO while allowing the subpoenaed testimony to proceed. 100 feet was the order. They could have simply gone on recess for 15 minutes, let Aura exit the courtroom, bring Maricini in, let him do his testimony, and then rinse and repeat with another 15-minute break, and their testimony's done, over. Courts do that all the time. I've never seen a court not accommodate something on the basis of a DVRO. This is based on the rules that Gingras plays under. Arizona Rules of Civil Procedure 2016, Arizona Lexus 259, Arizona Rule of Criminal Procedure 5.1, Arizona Rules of Protective Orders Procedure Rule 38. And then there's supporting cases for all cases, supporting cases for all of this. And so I guess the long story short, too long didn't read version is Gingras is full of shit. And I really hope that the state bar just doesn't let him present an argument like that with a straight face and just not do anything about it. I guess the third thing that he's arguing is posted a video of his client lifting her dress above her boobs. So redacted charge contains several vague comments about information I posted about this case, including certain identified photos or videos. Redacted claims one such video purportedly shows his client Laura Owens in a manner that may be deemed inappropriate for public disclosure. She further explains, Gingras posted a video of his client lifting her dress above her boobs, showing her blue bra and black panty lines. What on earth is redacted talking about? And why on earth would any sane lawyer post a video of his client lifting her dress above her boobs? Here's why. Because on January 3rd, 2024, Clayton's counsel, Mr. Woodnick, filed a motion for sanctions in the paternity case. He states the case. In that pleading, which he later withdrew, but not before the JFC cult seized on it, Mr. Woodnick accused Laura of appearing in court wearing a fake moon bump to falsely make it appear she was pregnant. Mr. Woodnick claimed this happened during a videotaped court appearance that took place on November 2nd, 2023. Again, before I was Laura's counsel, he wanted to point that out because he would have never allowed that to happen. Yes, that is an astonishing allegation to make, but Mr. Woodnick made it, as shown below. To be fair with the entire complaint, that allegation, which really wasn't one of the main featured complaints against Gingras, I don't think that it had a whole lot of weight behind it. But anyway, during the proceedings, he's just reciting stuff that we've already read. So, as it turns out, Mr. Woodnick's moon bump story was completely false. He simply lied to the court about this point in an effort to make Laura appear crazy. That is an extremely defamatory statement in and of itself, would it not be? He's claiming that Woodnick lied about this story. This was a lie. That is not qualified as anything. That seems to me to be a defamatory statement made to the Arizona State Bar with regard to Mr. Woodnick. I would have reported this false statement by Mr. Woodnick to the State Bar as a clear violation of ER 3.381, but I understand the bar has an unwritten policy against considering complaints filed by lawyers in pending litigation. In any case, this cruel gambit unfortunately worked exactly as Mr. Woodnick intended. The JFC cult seized on the story and repeatedly spread Mr. Woodnick's moon bump claim far and wide. An anonymous cult member even created a new Twitter account mocking Laura, showing a photo of her crying while being dragged away by police and suggesting lock her up. Also note that the moon bump Twitter account has tweeted 980 times about this case. There's people interested in it. There's no doubt about it. Who is trying to send me stuff? What is this? Oh, this was a tweet from Gingras. Somebody sent me a tweet from Gingras. I guess the summary was Clayton wins again, yawn. Basically, Fisk admits Mata's ruling contains findings that were not based on the evidence, but then says this isn't necessarily proof that Mata broke the rules. And I think she explained herself really well about why that was. Let me get back to this. I think somebody else is trying to send me stuff. Oh, it's Brad. What's up, Brad? I should have had Brad on the live with me. He would have stopped me from going mute for like 5 minutes or however long it took. Pam was calling me frantically. It's like, hey, dipshit, You're muted. How do I stop that from doing stuff? I'm again, I'm sorry for that, folks. All right. I apologize for the pause. Where was I with this complaint? All right, so this is the stuff that he's talking about, the moon bump stuff. So as the old saying goes, oh my God, with this guy, his literary sayings, as the old saying goes, a lie can travel halfway around the world while the truth is still putting on its shoes. In this instance, where the F is that from? Is he making that up? Hold on, I got to Google check that. Did he make up that quote? If I don't find the source of it when I hit Google search on this copy and paste, Mark Twain. The quote, a lie can travel, is often attributed to Mark Twain, but there is no direct evidence he said it. It's all right. Well, it's from somewhere. He didn't make it up. All right. So in the instance, this is exactly what happened. After Laura hired me, and after suffering months of damage caused by Mr. Woodnick's cruel and patently false moon bump story being spread online, Laura asked me to help stop the damage. To do this, Laura asked me to publish a video she took of herself 24 hours after the court appearance in which she allegedly wore a fake belly. This video clearly showed any allegation of her wearing a moon belly was completely false, because her swollen belly was clearly real. The tweet where this video was posted is shown here. As many have speculated, what is up with the... Am I seeing stuff, or does her face look incongruous with her body? I don't know. That looks like she just ate a big ass burrito or something. I don't know. That doesn't look to me like a pregnant belly. Pregnant bellies are like, there's like an, I don't want to, but that's been speculated about long enough. It just, people do not agree that that's a pregnant belly. People think that might be something else. But did her belly look like that in court when she was showing off her moon bump? I seem to remember that picture. She was like fully clothed or something like that. The court picture anyway. So again, this video was posted with Lauren's written consent and at her request. So this is not an ER 1.6 issue. While this sort of thing may seem very strange in any other context, in this situation, I believed it was necessary and appropriate given the vast amount of false information previously published online. Yeah, most good attorneys that I know wouldn't give a shit about what's being posted online, and they would litigate this thing in the courtroom so as to not subject their client to undue harassment and vitriol from people that disagree with very obvious evidentiary shortcomings that your client is making to support her arguments that she's making. 5, he arranged for an excessive security detail, including a bomb squad. Okay, so welcome to the crazy world of the JFC cult. I see in her June 26, 24 email, redacted self-identifies as part of the Justice for Clayton Collective. Interesting term. I have very little response to these specific allegations except to say, no, I did not arrange for the bomb squad to appear at trial on June 10th. To be fair to Gingras, that seems like just a far-fetched request, like you're calling 911 asking for a bomb squad because somebody may be violating a restraining order. I don't believe that he specifically requested that. Whether or not they showed up or not may or may not have been his specific request. If they were, it certainly had nothing to do with me. Okay, so I have no idea what drug sniffing dog is referring to. If there were any dogs present at trial, I did not notice them. So he's just basically pleading ignorance to whether or not they showed up or not, I guess. Court security did provide an escort to and from court for myself and Laura. They will do that if you request it, which is one of the reasons why they don't give a shit about witnesses who have DVROs against them showing up to court to testify, because there's protections in place. This was done at Laura's request because she had received death threats from JFC cult members, and because, to be fair, That's a move that I might have done, requested an escort to and from court because of the media speculation to calm my client down. Fair play to Gingras for doing that. I have no problem with him doing that actually at all. Especially if it wasn't specifically for any of the named restraining order recipients. If it was specifically to guard against the unknown from what would have appeared from their perspective to be a very hostile mob. Not that they were hostile, because they, by all accounts, everybody seemed to be pretty friendly. But I could see why he would do that. So number 6, he made an unwarranted 911 call during which he followed the witness and disclosed personal information to the operator. As explained above, Laura had and still has a valid lawful court order from the state of California, which, again, with this, 300 feet, not 100 feet. On the morning of trial, Laura informed me that she saw Maricini in the parking lot within 300 feet. The guys were fully on notice that he was going to be there. She then asked me to contact law enforcement to ask them to enforce the DVRO. She also contacted law enforcement when the very next day she saw Gillespie, Maricini, and Eckert all unified in an Instagram post, unified in a prayer without mentioning Laura Owens' name whatsoever. She initiated a call to law enforcement herself. So the fact that she requested it means nothing to me. I initially contacted court security, but they advised they were unable to help. They specifically told me the only option was to call 911 and ask Riverside or Phoenix police to enforce the court's order, which they were required by VAWA to do. In response to the instructions from court security, I called 911 and reported the matter to law enforcement. Jesus Christ. For whatever it's worth, Judge Mata's division specifically instructs all parties and counsel to call 911 if they believe they are in danger of physical harm. Below, if they believe that, yes, if they believe that. But in this case, they were on full notice he was going to be there. They knew why he was there. They knew that he was officially subpoenaed. They knew he wasn't going there with any malintent. He was literally complying with a legal order to testify. That doesn't lend itself in that context to a genuine belief of physical harm such that it would require you to call 911. That's the kind of bullshit lawyering that I hate. These snively little freaking lawyers, man, that do this shit. They're protected under oath because it says if we believe we're in physical harm without stating the context in which that call was made. It really just chaps my ass. Something awful. And he goes on, here's an excerpt from an email I received from Judge Mata's clerk. While the court cannot provide legal advice, blah, 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 if a party or anybody's in danger, call 911. Yeah, I tell my clients, hey, if you think well, what happens if the such and such, well, call the cops, call 911, don't call me, call 911. What am I going to do? Call the cops who are going to show up with guns and tasers and whatnot and do what's necessary. For all I know, I mean, the first person you call if you're in danger is not your lawyer. You call law enforcement. So clearly, Laura had every right to ask law enforcement to enforce. The correct way to state that is people who have a genuine fear of danger to their physical person or otherwise have every right to contact emergency services when threatened. But people who are on notice of something happening pursuant to litigation, know what's going to happen and try to use these people that may have genuine fears of imminent harm to their body or person or otherwise as an attempt to intimidate a witness. That to me should be punishable by the Arizona State Bar. I'm not really too mad about anything else that he's done, but this bullshit really chaps my ass. And that's the second time I said that this night. Second time I said that today. That was a bullshit move under any measure, and he knows better. And the fact that he's citing this bullshit, these boilerplate things that we tell people that, look, if you're so cared, don't be afraid to come to court. There's protections in place. You can call the cops, call 911. It gives the instructions. And then he tries to use that to shield his attempt to intimidate is disgusting. So, all right. She had every right. All right. Advising calling 911 was the proper recourse. So that is what I did. There was nothing improper about this except for all the reasons I just stated. I have no idea what redacted is talking about when she says that during the 911 call, I followed the witness and disclosed personal information of the operator. If the witness is referring to Mr. Maraschini, that allegation is simply false. I stayed with near court security personnel during his entire call or this entire call. And when Phoenix police arrived, I provided them with a copy of the DVRO and I explained the situation to them. I didn't follow anyone, nor did I disclose personal information to anyone other than law enforcement. I assume the personal information redacted is referring to is Mr. Maraschini's date of birth, which is listed on the DVRO, and which Phoenix police specifically asked me to provide to them. In any event, I believe this responds to all specific allegations in redacted's charge. If you believe I have missed something, I would appreciate it if you could let me know the specific allegation you feel needs to be addressed. I will be glad to update this response. Very truly, David Gingras. And there it is. Now there are exhibits, and it's some of the stuff that he's already referred to. I'm not going to go all the way back through all of them. So that, in a nutshell, is Gingras's response to the state bar. And I have this to say. Oh, is this more people? Somebody wanted me to look at this. Okay. So with respect, Dr. Dean's testimony is medical. Oh, I need to get that off the screen, don't I? Hey, Jessica, thank you so much for the 20. Gingras has an ego the size of Texas. Here's some whiskey money to wash away the bad taste of the narcissism. That's not even the worst I've seen today, ma'am. I've seen well, it's just been a hell of a day. But yeah, he has an ego the size of something, for sure. I appreciate you, Jessica. But this, I think, speaks to, let me embiggen this, speaks to, oh, you know what I should do before I go about sharing this? Is this on YouTube or is this something that I could just do that? Yeah. All right, so let me pause. I think this speaks to the specific order that Judge Mata made with respect to talking about medical stuff. So let me stop sharing this and go into that in the hopes that I'm going to do this right. Nope. I shared the wrong thing. Okay, let me try that again. Does it have to be? Oh, here we go. I could just do a window. There we go. All right, so let me bring that up. So this is specifically February 21st. I think this is Judge Mata addressing disclosure of medicals. How do I play it? Stop it. All right.
Not considered or not fully considered, but it's being taken even further, and her documents are being, I have no doubt that the second we send over that disclosure statement by the end of the week, all of her records will be on Reddit. And so, Your Honor, I don't believe that I understand where the court is coming from. And I think that had there been some sort of an agreement, we've offered for the documents to be shared between counsel. I've offered for him to come to my office and see the documents. And we've had some discussion about that. Obviously, the recent pleadings, I think, may change from the court, but it's not us trying to hide the ball. It's us trying to make sure that my client's medical records aren't shared with the entire world.
All right, we'll have the minute at Gray reflect that no party is to disclose outside of themselves any medical or other documentation disclosed between the parties. That goes both ways. I don't want anyone releasing any exhibits, medical records, or anything else regarding the other person. And that goes both ways, and truthfully should go without saying, but I recognize it does not in this case. I am going to order that the records be disclosed dating back to August of 2020. That's 1 year prior to the first filing. I think that that's appropriate. Mr. Woodnick, do you have a release with you today that she can sign?
I've sent that.
Well, that seems pretty emphatic, doesn't it? That was pretty clear. Neither party on either side, for any reason, is allowed to release any medical documents whatsoever, and you should know better. It's pretty much what the judge said. I don't see how you could misinterpret that the way that Gingras was trying to spin it. But I think if you just got to read the transcript from that hearing, it's not arguable that you can interpret that any other way. Don't share medical stuff on the internets. Share it amongst yourself. And the fact that he's going to say, oh, well, she had some different attorney before me. That was before my time. Bullshit. You're the one that took the case on. You're responsible for being aware of all of those kinds of orders. You were derelict in your duty of keeping those things private. You were doing it for your own personal trolling of the JFC community or whatever you're wanting to call it. And so that to me should be admonishable at the very least, punishable at best. I mean, I don't think he should lose his license over it, but somebody should put him over his knee. Something. Yeah, that's what I thought I heard. And he's saying that, oh no, it was all fair game. There was a motion to do something, but the judge pretty clearly stated what she expected of the parties. And it didn't really include exceptions. There was no exceptions to that. I think he might be okay with posting Clayton's depo for the reasons that he stated in his response. And I think that he wrote it that way because it gives merit to his thought that, hey, there was a motion filed and the motion was denied, so I thought it was fair game, except that was in January, except a month later, Judge Mata pretty much clarified, no, I don't want anybody exchanging or disclosing or releasing any medicals for any reason whatsoever. Share it amongst yourselves. He failed to mention that part to the Arizona State Bar, didn't he? That is what you call selective pleading, isn't it? That's the kind of thing that attorneys do when they don't want to highlight the strengths of the other side's arguments. And so, yeah, man, there's a lot going on there. And Gingras, I don't know. I don't think he's going to get away with that. If you ask what my opinion is as a practicing attorney, the worst thing out of all those things that he did is the witness intimidation part. That really pisses me off. There's not really an excuse for that, for a lawyer to go that far to prevent a propensity witness from testifying at trial. He didn't need to do all of that shit, man. And he knew better. I don't know. Maybe he hasn't really practiced family law all that long, or has that much of familiarity with how restraining orders work. Maybe because in 20 years that he's been practicing, he's been doing other stuff, I guess. But he took on this case. It was a high profile case. The world was watching. And if not the world, at least a lot of people were watching. And they saw how he practiced, and he failed to know how things work with respect to laws. Yeah, there are laws that state that, but he failed to know the exceptions. And you don't get to make an excuse. You don't get to plead ignorance of the law when you're a lawyer. I don't know if I'd go so far as to saying it should be like potentially criminal witness intimidation, like terrorist threats or something. But it's certainly conduct that should be punished. To what degree? I don't know, man. I don't get to make the call anyway. Zoe B says, and the judge ordered medical records back to August 2020, and Laura failed to comply with that based on her own statements about the missing Planned Parenthood. Yeah, that was a lot of confusion. It's like where the judge was trying to fill in the gaps, and the gaps just never got filled, not even when she was sitting there on the witness stand on June 10th. So there is that. Folks, I'm about to lose my voice. It's been a hell of a 48 hours. And I apologize with not coming out with a live on Monday or on Tuesday. There's just been a lot going on. My grandma passed away, and I was dealing with that, and it just kind of happened really abruptly, and the whole family was involved, and so I was pretty much unavailable. But I got many of your well wishes and all of your DMs, and thank you guys so much for that. And again, I apologize for my absence. Been through the ringer, and I'm trying to get back to some kind of level of normalcy, but that'll come a time. And for the rest of everything else, thank you all. I'm going live tomorrow. If you're not already subscribed to it, find my podcast, the Tilted Lawyer Podcast. It's on Apple, the Apple Podcast, Spotify, Castbox, whatever podcast subscriber carrier that you subscribe to. Find my podcast, download it, and start getting caught up with all of the stuff that we have. We are releasing exclusive audio only podcast shows. We're going to be starting YouTube memberships. If you are a member of our YouTube channel, you will have the ability to listen to our audio only podcast live. You'll be able to see those before those get published to the RSS feed and all those things. There's lots of crazy stuff going on. So that's, and if you happen to have, some of you have already received the merch that we released like a week ago. Some of you have shirts and hoodies, and Pam has this big ass mug, the good old honest, what do they call it? The super pint or whatever. She has a big ass mug that says Tilted Lawyer on it. It's pretty cool. Get yourself some stuff. Pam, thank you so much again for the 10. And thanks. I appreciate that, Pam. You don't even know. It's been rough, but I love you all. I got to check out. I will catch you guys tomorrow. It's been a fun one. Love you all. Bye-bye.